This case number 21 CR 194, State of Ohio versus Jerry Wayne Berry Jr. You're Jerry Wayne Berry Jr.?
Yes, I am.
Right. Mr. Berry is represented by Mr. Gilman, President of the State, Assistant Prosecutor King. The matter before the court on the proposed bill of information and a waiver of prosecution by indictment for the plea. Now, Mr. Berry, appears you were charged in the Hillsborough Municipal Court on November 15th with sexual battery.
It was bound over as rape.
Right, it was bound over to the grand jury on the charge of rape. And so the matter is pending before the grand jury. Now, under the law, Mr. Berry, no person can be required to come before this court to face a felony charge until unless that person has been indicted on that charge by the grand jury of the county. Now, the grand jury is a group of 9 individuals who live in this county who serve for the term, usually it's 3 months at a time. And their responsibility is not to determine whether someone is guilty or innocent, but to review the evidence that's submitted to them by the prosecutor's office under oath, and then make a decision as to whether or not there's a probable cause evidence to believe that a crime has been committed to the extent that it warrants that case being indicted and that person being required to come before the court to defend against it. Now, since they are not determining guilt, it only requires that 7 of the 9 persons on the grand jury vote to indict. If fewer than 7 indict or vote to indict, then there is no indictment and the case stops there for that period of time. Now, it can be represented in the future, depending upon any developments in the case for future consideration up to the statute of limitations, which actually for rape, I think there is none. I think that totally. Now, you have not been indicted yet by the grand jury, and so you're not required, you can't be required to come before this court for any charge. However, there is a provision under the law that's recognized as an exception to that, which is what's called waiver of prosecution by indictment. And waiver in a legal term means to give up. And so a waiver of prosecution by indictment means that you're giving up your right to have the grand jury hear evidence about your case and decide on what charge or charges, if any, should be indicted by a vote of 7 or more. And if you do that, then that means that instead of the grand jury making a decision to indict you and returning a bill of indictment, the prosecutor's office files what's called a bill of information. Now, the bill of information basically is the same document as an indictment, except that it's only signed by the prosecutor because the prosecutors won't sign it because of the way that the indictment is. If it was an indictment, then the prosecutor signed it, also the 4-person grand jury would sign it to certify that the grand jury had returned that bill. And so I have a proposed bill of information here that consists of 2 counts, and the first count alleges an on or about the period of August 1, 2021, continuing through August 31, 2021, in Highland County, Ohio, Jerry Wayne Berry Jr. did engage in sexual conduct with, is that IH or LH? IH. Okay. That's correct, Ms. Collins. Okay, thank you.
IH, Your Honor.
Not the spouse of the said Jerry Wayne Berry Jr. The said Jerry Wayne Berry Jr. being the natural parent, adoptive parent, step-parent, guardian, custodian, or person in loco parentis to LH. And loco parentis means acting as a parent, like living in the same household as a companion to one of the parents. In violation of section 2907.03A5. Then the second count alleges the same offense, but that it occurred during the period of September 1, 2021, continuing through September 3rd, 2021. So 2 different charges are the same except the dates. First count is August 1 to August 31. Second count is September 1 through September 3rd. Now, both of those are called sexual battery. And those are violations of section 2907.03A5 and are third-degree felonies. And so the agreement is, as I understand it, that you will agree to come to court on these two charges without the grand jury being required to meet. And in exchange for that, the state's going to use the charges the state's going to file instead of seeking an indictment on rape, which is a first-degree felony and in some circumstances could carry life imprisonment. Now, you understand what this process is? I'm sure you've talked to your attorney, but I have to ask for on the record.
Yes, I do.
Okay. And so, are you in agreement to give up your right to have the grand jury consider this matter and the court looking before the court? And
Yes, sir.
you come before the court on this bill of information?
Yes, I do.
All right. Well, I have a form entitled Waiver of Prosecution by Indictment. And it reads that I, Jerry William Berry Jr., having been informed by the Court of Law on constitutional rights, my right to be prosecuted by way of indictment, being represented by Stephen Kilburn, attorney at law in Lebanon, Ohio, do hereby freely and voluntarily waive prosecution by indictment. Agree to proceed in this matter by bill of information, dated 12/27/21 today. And then right below that, there's a signature line that says defendant, and it's at your signature right below that date.
Yes, it is.
And that's your attorney's signature below it. And you just signed this document this afternoon.
Yes.
All right. And have you been threatened in any way or to, I guess you do this?
No.
You're innocent, pretty well.
I am.
Now, the next step in the case would be to enter a plea. And normally, if a person's indicted, they come before the court 99% of the time they enter a not guilty plea, maybe 99.9% of the time they're not guilty. And then that starts a process of defending against the case where there's an order issued that sets a schedule usually. The attorney for the defendant asks what's called discovery, where he gets copies of all the reports and witness statements, any exhibits, recordings, etc. Information about the witnesses, addresses, if they've been in trouble before, such that it can be brought out in court, things of that nature, and then possibly filing motions that might be directed toward any alleged violation of rights that may occur, such as a motion to suppress a statement or a search, results of a search, or something like that. Now, if you agree to come before the court and plead guilty today, then you won't go through that free trial practice. Now, are you satisfied that your attorney has had enough time to meet with the state and obtain all the information that you think is necessary for you to make this decision today?
Yes.
Okay. So you don't feel that you're being pressured or rushed into doing this without going through some of the formalities that would normally occur?
No.
Okay. Then there is did you just get the bill of information this afternoon, or did you have a draft of it?
I received it within the last week or so.
All right, so your client has had some bill information for at least 24 hours before today.
Yes, Your Honor.
Okay, all right. And you understand, you're aware of the charges and whatever before today?
Yes.
Okay. All right, then the next step then would be to enter a plea. Now, the agreement here is that you're going to, instead of withdraw your form of not guilty plea, I'm going to strike that out, just because you're just entering a plea. So I'm going to strike out withdrawing the form of not guilty plea, and so it'll just read, I enter a plea of guilty to the following offenses. And then it says count 1 and 2, this is on page 1 of the agreement, sexual battery, 290703A5, third-degree felony. Then it states below that you understand the maximum penalty for each of those counts is 12 months to 60 months. There's a fine of up to $10,000 available now on each count. And those sentences could be ordered to be served consecutively, one after the other. So that means there could be potential, if they were served consecutively in 24 months, 12 on each of the minimum, up to 120 months, which would be 60 on each second, plus a fine of up to $20,000. Do you understand that?
Yes.
Are you facing any felony charges in any other jurisdiction? Are you currently on probation, in control, parole, or post-release control for a felony?
No.
Now, in addition to the possible sentence of 12 months to 60 months, your sentence in prison, serve a prison term. Once you complete that prison term, it is mandatory that you be put under what's called post-release control under the supervision of the adult parole authority for a period of 5 years. Because all sex offenses are required to do that. So you'll be supervised by a parole officer on the term set by the adult parole board. The court judge has nothing to do with that. If during that period of supervision, the parole board determines that you have failed to comply with the conditions that they have set forth, they can return you to prison, even though you served the entire term set by the court for an additional period of up to 9 months for any one violation, up to a maximum of 1/2 of whatever prison term is imposed for all violations. However, if you committed a felony under supervision during that 5-year period, again, it will be 5 full years from the date of your release. Then, in addition to whatever sentence that judge could impose for the new offense, that judge could also sentence you to an additional term of 1 year, or whatever time is left on that 5 years of post-release control, whichever is greater, for committing a new felony while under post-release control supervision in this case. If that occurs, that sentence has to be served by law, separately to the sentence in the new case being enacted. Do you understand that?
Yes.
Now, one additional consequence of this conviction of this offense is a requirement that you be designated as a Tier 3 sex offender, which means that you will have to register in person with the sheriff for this life. And that would be every 90 days. Now, and then there are penalties if you fail to do that. There are other requirements also with that, which I don't explain until the time of sentencing, but you will be required to do this. This is collateral, what they call collateral consequence, and be required that you do that. You understand that?
Yes.
Okay. Now, under the law, Mr. Berry, it's not mandatory that the court sentence someone who's victim of this offense to prison. I can tell you that it's usually what happens. In fact, almost always what's happened in this judgment. But under the law, the court is not required to do that by the law. Instead, the court could develop what's appropriate, put you under community control supervision, be supervised by a probation department under the terms and conditions set by the court for a period of up to 5 years. Now, if during that period of time the probation department felt that you were not complying, then they could file a notice of that with the court in writing to serve a copy upon you. You would then be entitled to have a hearing and be represented by an attorney at that hearing. If the outcome of that hearing was that you failed to comply, then at that time the court could terminate or revoke community control, then sentence you to prison for the 120 months and fine you $20,000. Do you understand that?
Yes.
Okay. Now, I just read you the bill of information just a few minutes ago. You recall that. You know what it is you're charged.
Yes.
So, do you understand what the state is saying you did in each of those charges, when, where, and how they allege that you did?
Yes.
Do you understand the possible penalties for those offenses and collateral consequences?
Yes.
Now, have you discussed the nature of those charges, the evidence in the case, the possible legal issues in the case, the possible defenses you try to raise in trial, the possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with his advice and confidence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Are you taking any prescription drugs?
No.
Has anyone threatened you to make you plead guilty here today?
No.
Now, the agreement says on page 2 there's 3 sentences that are printed in bold near the bottom of the page and underlined. Those read as follows. Defendant shall enter a plea of guilty to the bill of information. State defense jointly recommend 30 months incarceration on count 1. Consecutive 30 months incarceration on count 2. Defendant shall be a Tier 3 registered sex offender. Is that your understanding of the agreement?
Yes.
Does anyone promise you anything other than that to get you to plead guilty here today?
No.
Under the law, the matter of sentencing is up to the judge, not to the parties. So even though there's an agreement that you should get the 60 months or half of the possible sentence, once I've heard all that information that is presented to me about the case, if I decide that's not the appropriate sentence, I could sentence you to less time, or I could sentence you to more time. Sentence you to anything between 12 and 120 months that I thought was appropriate, plus fine you $20,000 in addition to designating you as a sex offender. You understand that?
Yes.
And has the victim been consulted or been represented regarding this matter?
The victim's mother has been consulted, Your Honor. She was initially consulted back on November 30th. She indicated at that time that she approved of this agreement.
Okay. Now, Mr. Perry, do you hold any kind of license or certification from any state agency that regulates any kind of profession like nursing, anything like that?
No.
Now, you have certain constitutional rights, you understand, before I can accept the plea of guilty from you. First of all, you have the right to counsel. Mr. Gilbert was employed to represent you. Now, under the law, if you didn't have the funds to hire or continue to pay him to defend you, then the court would, on proof of that, appoint an attorney for you at no cost to you. So the reason I say that is I just want on the record that you're not pleading guilty here today because you don't feel that you'll have enough money to properly defend yourself in this matter. Is that a concern of any at all?
No.
Okay, thank you. Now, Mr. Berry, you have a right to have a jury trial in this matter. And that means that 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial day. Now, after 12 were selected from that group of citizens, then the evidence would be presented and that jury would be instructed on the law. Then that jury would have to decide by a unanimous verdict, meaning all 12 would have to agree as to whether the state proved your guilt on either or both cases. It would have to be, if each case is separate, each count separate, it would have to be unanimous verdict, all 12 making a decision on guilty or not guilty. Now, if you didn't want to have a jury trial, you can waive, and which means give up in writing your right to have a jury trial. And then in that case, instead of a jury of 12 people hearing the evidence, applying the law, the judge would be the one who would hear the evidence. The judge would apply the law. The judge would make the decision as to whether or not the state proves your guilt by proving beyond reasonable doubt in either of both cases instead of a jury. Do you understand that?
Yes.
All right, now, Mr. Berry, under the Constitution, you have a right to confront the witnesses in this case and in open court and cross-examine them through your attorney. What that means is witnesses have to come in and testify in front of you and your attorney and anyone else who would be present at the trial. After the prosecutor was done asking questions of those witnesses, then your attorney can ask questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes.
Right? Now, under the Constitution, you have the right to use the power of the court to compel or force witnesses to come to court and testify for you, just like the state. So if you have witnesses you're not certain going to come in voluntarily, a jury request court issued 4 orders of subpoena. That would force those witnesses to come to court and be able to testify if you wanted them to, even though they didn't want to be here. This is exactly the same way that the state's witnesses are forced to come to court to testify against you. Do you understand that?
Yes.
Right now, under the Constitution, you have a privilege against self-incrimination. What that means is that you cannot be forced to give evidence in this matter at any time, including the trial. So no one can ever make you testify. The prosecutor can't make you testify. The judge can't make you testify. It is your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one can even comment about it except in one situation, and that is if there is a jury trial and you do not testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes.
Right now, under the Constitution, Mr. Berry, you are presumed innocent of each charge until proven guilty by the state of Ohio of every essential element of each of those charges by proof beyond reasonable doubt. So what that means is that the burden of proof is on you to try to prove you're not guilty of these charges. In fact, at trial, you don't have to present any evidence in your defense on either charge. Now, you may, but you're not required to. But whether you present any evidence in your own defense or not, the burden of proof will stay on the state of Ohio to prove your guilt on every essential element of each offense by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Right now, as I mentioned earlier, at this point in the case, there's 2 possible pleas. Possible plea of not guilty, which means that you deny the allegations in the bill of information, you deny you committed any crime, and then you exercise all the rights that I've just described for you this afternoon. Now, if you plead guilty, which is what this agreement says you're going to do. That is the opposite of a non-guilty plea. A guilty plea admits the allegations in the 2 counts of the indictment, admits that they're true, admits that they're crimes, and admits that you're the one who committed the crimes charged in those 2 counts. And that plea waives gives up all of the rights that I've just described for you this afternoon, except the right to have an attorney, because you always have a right to have an attorney no matter what you plead. With that exception, your plea of guilty waives gives up your right to have a jury or a court trial. It waives gives up your right to confront witnesses against you and to cross-examine them through your attorney. It waives gives up your right to use the power of the court to compel or force witnesses to come to court to testify for you, which is like a mistake. It waives gives up your privilege against self-incrimination because you're saying you're guilty, and that's what she was defined guilty. And waives gives up your presumption of innocence because if you say you're guilty, then the state doesn't have to prove you're guilty. Now, plea of guilty also waives gives up any right to file an appeal that you think you may have had up until this point in time in the case for any alleged violation of your rights. And finally, it subjects you to being sentenced immediately by the court. Now, do you understand all of those things?
Yes.
And you are a U.S. citizen, Mr. Berry?
Yes.
And you are entering into this agreement to plead guilty voluntarily?
Yes, I am.
I don't think I said this, but in the event you did waive your right to appeal with the plea guilty, there are some limited circumstances under which you could appeal, including if I sentence you to maximum sentence. That would have to be filed within 30 days of your sentencing entry being filed. You understand that?
Yes.
All right, Mr. Berry, do you have any questions about the waiver of the prosecution by indictment of the grand jury and agreement to come forward plead guilty on this bill of information?
No, I don't.
You understand that process and what's going on?
Yes.
And you understand what you're giving up instead of waiting to be indicted and defending against the charge?
Yes, I do.
Do you have any questions about the charges or the possible penalties?
No.
You understand it?
Yes.
Do you have any questions about the plea agreement?
No.
You understand it?
Yes.
And again, you understand that the recommendation on sentencing is not binding on the judge. Do you have any questions about the constitutional rights I explained? You understand those?
Yes.
Do you have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
No.
You understand it?
Yes.
All right, is there anything you'd like to speak with your attorney about before we go any further?
No.
Do you have any questions about anything that I've explained to you or that's taken place so far in this proceeding?
No.
That is, it's your decision to plead guilty to the 2 counts set forth in the bill of information according to the terms of the plea agreement that we've just done. Is that your decision?
Yes.
And it's voluntary?
Yes.
All right. You can speak up.
Okay. I'm sorry.
It is voluntary?
Yes.
Okay, thank you. All right, then as to count 1, which alleges that on or about the period of August 1, 2021, and continuing through August 31, 2021 in Tyler County, Ohio, you did engage in sexual conduct with I.H., not the spouse of the said Jerry Wayne Berry Jr., the said Jerry Wayne Berry Jr. being the natural parent, adopted parent, step-parent, guardian, custody, or person in local occurrence to I.H. in violation of section 2907.03A5 of the Ohio Revised Code, the charge of sexual battery, a third-degree felony, carrying a potential sentence of between 12 months and 60 months in prison, a fine of $10,000, and a required designation as a Tier 3 sex offender. How do you plead?
Guilty.
And as to count 2, which alleges that on or about the period of September 1, 2021, continuing through September 30, 2021, and in Highland County, that you did engage in sexual conduct with I.H., not the spouse of the said Jerry Wayne Berry Jr., said Jerry Wayne Berry Jr. being the natural parent, adopted parent, step-parent, guardian, custodian, person, local occurrence to I.H. in violation of section 2907.03A5, also the charge of sexual battery, third-degree felony, the same penalties I just described to you for count 1. How do you plead?
Guilty.
Okay. All right, the court finds on this day in open court, the defendant was deprived of all his constitutional rights, made a knowing, intelligent, voluntary waiver to say pursuant to Criminal 11. Please accept it for trial. The court finds the defendant guilty of 2 counts of sexual battery as charged in counts 1 and 2 of the bill of information. There's not a request for a pre-sentence investigation. I will order one. I am going to order that the matter be set for sentencing For January the 31st, it's a Monday. At 1 p.m. Now, until then, the court will order that you be released on your own. Well, let's see, was there a previous bond posted this?
Yes, there was a problem posted.
Here it is, $50,000, okay. So the previous bond posted will continue. Plus your OR. And your OR is your promise to appear at your sentencing hearing. And if you fail to appear, then you could be prosecuted for an additional felony, and if convicted, sentenced on that regardless of what happens in this case. There's also a service fee of $106, that's to be paid in 30 days to the clerk. Then we require to report to the probation department immediately after court, and during the pendency of the case, we report to them once a week or 4 weeks after that as they determine in the manner they determine. They do a random drug test and they order, provide phone numbers for your home self-employer, have no contact with the alleged victim. I normally order house arrest, but in this case, since you already pled guilty, I will not order that. Unless something happens that the doctor thinks the court makes me feel that that should be done. So you can apply those others and we return and talk to you about that. But, should be no problem. Now, if you don't comply with those conditions and the court receives a notification that the probation department and the court could, or you picked up held pending for the court, and that's long, and sure your sentence, here's the sentence. Because under the law, now that you plead guilty, you're not entitled to bail until that. So make sure you can call. Now you get your assignment notice from the bailiff, which gives you your date and time up here. Then you can stairs and sign your OR bond. And then also, were you originally arrested, were you fingerprinted and photographed and everything out the sheriff's office? Then go down to probation, 117 East Main Street, it's just about half a block on the other side of the street, crossing the flagler station.
I think I actually have an appointment at 8 o'clock tomorrow morning with them scheduled.
All right, and then just go ahead and I'll give you till tomorrow. All right, I'll change that at the report at 8 o'clock tomorrow morning. All right, is there anything further, counsel?
There you go.
No, Judge, thank you.
Thank you.
Please rise.